and welcome to the second Global Experts Plenary at this CISDL Biennial Symposium, The Natural World, the Sustainable Development Goals, and the Law. My name is Mateus Garcia. I'm a project coordinator at the CISDL, and I will serve as one of your moderators for this plenary. Thank you.
Hello and welcome to all our participants. My name is Ilaria Colombo. Together with my co-moderator, it is my pleasure to introduce the chairs of our second Global Expert Plenary, Governing Trade and Investment, Natural Resources, and Bioeconomy Development. Professor Marcus Gehring, a fellow of Hughes Hall, former director of the Center for European Legal Studies in Cambridge University's Faculty of Law, and ad persona Jean Monnet Chair in European Sustainable Development Law. Professor Gehring serves as lead counsel for the Trade, Investment, and Finance program at the CISDL.
Professor Jorge Cabrera is a professor of law at the University of Costa Rica and serves as a legal counsel of the Biosafety and Biodiversity program of the CISDL. He's an expert in biodiversity law and has been involved in numerous international negotiations on environmental issues, including currently serving as a legal advisor of the National Biodiversity Institute.
And Professor Ilaria Espa, Associate Professor at USI, Senior Research Fellow at the World Trade Institute, and Lead Counsel for the Natural Resources Program at the CISDL. Her research focuses on international economic law and its intersection with environmental issues. Over to you three.
Welcome to the Center for International Sustainable Development Law's Biennial Symposium, The Natural World, the Sustainable Development Goals, and the Law. Thank you for joining us, and thank you to everyone involved in the first panel. That was a very impressive act to follow. The topic of trade, the bioeconomy, and natural resources, including investment, could not be more important. So a warm welcome to all our participants and the audience online, wherever you are in the world. Over to Ilaria.
Thank you so much, Marcus. Thank you so much, Professor Gehring. And hello, everyone. And thank you so much for joining us from my side as well. I really have the pleasure to be one of your chairs for this plenary together with Marcus and Jorge. And I have the pleasure to introduce our first keynote speaker for the session. We are extremely grateful to Dr. Balashnika Pisupati for agreeing to join our panel. Dr. Pisupati is currently head of the Environmental Policy Unit of the Law Division at UNEP, based in Nairobi. Is close to 2 decades of experience working on high-profile issues of sustainable development, environmental management, and policy development, including service as the head of the Asia Biodiversity Program for IUCN. So we are extremely delighted to have him provide our first keynote speaker of such an important topic, as Margaret has highlighted. And without further hesitation, I give him the floor. Thank you so much for joining us, Dr. Pisupati.
Thank you, colleagues. Thank you, a number of old friends and colleagues, but a number of new ones as well. You know, that's the beauty of panels, platforms like this. It also offers us an opportunity not only to exchange ideas, but also meet up with a number of interesting colleagues who actually pursue similar interests and similar areas of work focus. Of course, my presentation or intervention is going to be relatively focused and short, where I'm going to be touching upon 3 different components during the few minutes I have. The first 2 are my own personal experiences working on the issue of trade, biodiversity, natural resource management, access, and benefit sharing. And the third one is more related to the ongoing discussions we have been having in effectively realizing the Kunming-Montreal Global Biodiversity Framework within which, as many of you would have realized, have targets that are directly linked to the discussions related to trade and bioeconomy. Now, of course, the word bioeconomy will find more and more hits, more and more space in the coming months, thanks to the upcoming G20 meeting, Brazil. Certainly, this particular issue is going to receive a lot more of attention, both at the expert level as well as at the ministerial level. Let me very quickly mention, two of my experiences. Both of them related to the issue of policy and legal coherence or connections in terms of trade and natural resources or biodiversity. The first one is my experience working, in India as the chairperson of the National Biodiversity Authority, where in India we have a legal framework, the Biodiversity Act. And the focus of the Act is to protect and conserve and manage bioresources, but also ensure that when they are used for commercial purposes, the benefits are fairly and equitably shared, with a number of provisions related to access and benefit sharing. And very interestingly, when the government actually developed and proposed a new trade regime, a trade policy that is supported by a number of adjustments to the existing trade frameworks, one of the things that caught the attention was the incoherence, if I may use that word, between trade and natural resource management or conservation priorities. On one hand, the Biodiversity Act focused on the issue of conservation. On the other hand, the trade policy focused on enhancing more and more extraction, more and more harvesting of resources, so that the trade component of it for export markets are better realized, with a lot of subsidies being given. And I'm just leaving that particular point for you to think about the link between trade and biodiversity from a national perspective, because many countries do have this kind of a challenge, where on one hand, from an economic and trade perspective, we follow the issues of how to maximize profits, how to extract, and how to make our exports import balances work well. But on the other hand, we have huge challenges related to conservation. The second issue is related to trade and access and benefit sharing. In many countries, of course, now thanks to UNCTAD, Lorena is online, a significant amount of work has happened on the issue of trade and access and benefit sharing and biotrade. But still, many countries struggle with a very simple issue of how to value and how to look at the market, accomplishments or market prices for biological resources. Again, my own experience working in India, we had close to 200 species of bioresources, all clustered under the trade classification into one customs code called miscellaneous. So it was just impossible to track and trace what gets traded, how they are sustainably harvested, what is the impact of all of it from a conservation viewpoint. But now, thanks to a number of interventions and awareness in terms of expanding the customs coding classification system, that countries are actually looking at more than the 6-digit classification. So from a legal and policy perspective, that is also something which will definitely have an impact for many countries, as and when countries get more serious about implementing the Nagoya Protocol on access and benefit sharing as well. Now I'll shift to the 3 targets that I'll focus on in the context of Kunming-Montreal Biodiversity Framework. Target 5, that looks at sustainable, trade-related aspects of it. And one significant entry point for trade-related discussions in that context is that in as much as we are focused on conservation and access and benefit sharing, the sustainable use aspect of it in the context of the convention is still something that needs more work. And that is where there should be more coherence in terms of both legal and policy objectives in terms of sustainable use, harvesting, and dealing with target 5 of the Kunming-Montreal Biodiversity Framework. Then we have target 14 that looks at elements related to trade again. Policy coherence is extremely important, and it is the time that countries can get these things straightened up as and when they are updating and reviewing their national biodiversity strategies and action plans, but also setting national targets. And target 16, which certainly is also going to be very important for a lot of our discussions from trade and biodiversity and the convention's viewpoint, is on the issue of consumption. And again, policy coherence is something which is going to be extremely important. So a lot of entry points, a lot of interesting opportunities do exist for us in the context of overall policy and legal components, but there are things which are specific that can be dealt with at the national level as well. and experts and colleagues like you certainly will add more value and more focus on many of these issues in the days to come. So with that, I'll sort of stop and then hand it over back to the moderator. Thank you.
Fantastic. And I believe Jorge is next.
Please go ahead to introduce the first two speakers from the plenary. I think your keynote might be joining in the closing or may not be able to connect. So you can go straight into your plenary.
Okay, that sounds fantastic. I'm now turning to our remaining speakers. Dr. Alec Holim is Director of the Trade and Environment Division at the World Trade Organization, WTO. He has extensive experience in trade policy and its intersections with environmental issues. Dr. Lim has authored several authoritative publications on trade and sustainable development. And Professor Alessandra Lemon is a fellow of the CISDL, a professor at ESG and climate law, and president of the Brazilian Bar Environmental Law Commission, Rio Grande do Sul chapter. Professor Lemon has received numerous distinctions and prizes for her contributions, including recognition as the Sanford Woods Institute Rising Environmental Leaders Fellow and the Santander LSE W50 Scholar.
As well, joining us, Professor Ted Gleason as an Associate Fellow at CISDL and a Professor at the Grenoble School of Management. His research focuses on international business law and in particular the relationship between investment protection and societal concerns in environmental protection and sustainability. He also has significant experience as a licensed attorney with investor-state disputes. And Dr. Charlotte Siever-Gasser, who's a senior researcher of the SNSF Synergia project, making trade agreements work in the service of society at the Graduate Institute in Geneva, lecturer in international trade regulation at the University of Zurich, and assistant professor in public economic law, international economic law, and sustainable development at the Zurich Law School. Last but not least, certainly, we also have the pleasure of having Dr. Claudia Ituarte Lima, who's a thematic lead and senior researcher at the Raoul Wallenberg Institute and director of the Global Network for Human Rights and the Environment. She works mainly on human rights, biodiversity, and climate change issues, and has held previously numerous positions at high-profile and esteemed research institutions before her current role. So without further ado, I think we can definitely give the floor to Dr. Haid Olim and to Professor Alessandra Lemon to answer our first kickoff question on how can legal innovations from NC14 and diverse economic accords promote the bioeconomy. So Dr. Olim, you'll have the floor. Thank you so much for joining us again.
Thanks so much, Ilaria, and thanks very much, Marcus, and all the organizers for this conference. Pleasure to be with you. On your question, which is such a significant question, I like to start with something which I think is really quite basic, but I think fairly important, which is that I think we need to change the nature of the conversation. For a long time, the conversation in terms of trade and environment, or more specifically in this case, trade and bioeconomy, tends to be framed in terms of what is allowed under trade rules. It's a very limiting sort of conversation that says, let's look at the rule book and let's see what our spaces are there to promote environment or would actually allow environmental objectives to be achieved as an exception. And I think that's a recasting is really required. And we need to ask the question somewhat differently. And I think I'm encouraged by your set of questions for this conference, which is much more about how can we use trade rules to achieve what we need for environmental sustainability, for sustainable development, and in this case, bioeconomy. So a much more solutions-oriented discussion. What is needed? How can we use this system? And I think we're not yet there, of course. We're quite far away from that. But I think we're starting to see some very important discussions emerge in the WTO, but as well as outside of the WTO. In the context of the WTO, there are three very different types of initiatives. One is called Trade and Environmental Sustainability Structured Discussions. Another one, which is a very focused dialogue on plastics pollution. And the third one is on fossil fuel subsidy reform. I won't go into the details. We don't have time for that. My point of raising these three initiatives is simply because their starting question is very different. Their starting question is what I just mentioned, is that they are looking at how can the WTO, or trade policy more specifically, can be used as tools to achieve environmental sustainability, or to address a particular environmental challenge, such as plastics pollution, or in the case of fossil fuel subsidy reform, how can we actually repurpose subsidies so that they are not environmentally harmful, and in some cases also to ensure that they're not trade distortive. That's a very different type of agenda that we've not had at the WTO that much in the past. And this new type of work through our membership, I think, is very encouraging. It is not yet a multilateral process, I have to be clear. These are groups of countries, not the full membership, but it does cover a large segment of the membership. It's not a negotiation. I think that's the other thing I have to underscore. But it is about trying to find pathways, and I think that's really important. We already have one negotiation, which is so important to biodiversity, which is the fishery subsidies agreement negotiations. You already know that there were very positive steps taken. We're not yet there. It needs to be ratified. There needs to be additional provisions added. There have been some stumbling blocks. The failure to conclude at this week's General Council is something that the General Council Chair, the Director General, and as well as the Chair of the Fishery Subsidies Agreement are thinking through and trying to find out what are the next steps. And let me conclude with a set of very practical points that I think anyone interested in this area could reflect and think about. And I think the basic point, which Professor who gave the keynote already mentioned, policy coherence, which is so important, and that needs to be built from the national to the global, or the global to the national. Last year, WTO provided a publication called Trade Policy Tools for Climate Action. It was for climate action, wasn't for the bioeconomy, but actually, if you look at those 10 trade policy tools, they would also matter for the bioeconomy. Why? Because these are basic trade policy tools, and they are about trade facilitation, about repurposing subsidies, they're about government procurement, they're about services, and so forth. So in essence, the ingredients are there, but they have to be put together. And just as an example, one can think about trade facilitation for bio-based products, simplifying customs procedures, reducing trade barriers, streamlining regulations and standards, and so forth. One could think about specific environmental goods and environmental services, and to think about how can they assist the bioeconomy, and how can they be facilitated. There's the wider question of policy coherence, which could relate to SDG goals alignment with trade policies, and so forth. Several challenges exist. We don't have time to go into all of them, but I think one very key challenge that we have grappled with for a long time is the question of scope and credibility, and the existence of actual quality infrastructure systems that would support scope and credibility. What do I mean? For example, when we say bioeconomy products or bioeconomy in itself, to translate this into operational trade policy or trade investment facilitation work, there has to be some sort of baseline as to what is understood to be a bioeconomy product, for instance. What are the regulations and standards that accompany it? What are the certification requirements? Many of these things go beyond a trade organization, but a trade organization could work together with other partners to try to prepare that ground for the sort of facilitation of the bioeconomy through trade and investment. So let me stop there and pass it back to you. Thank you so much, Ilaria.
Thank you so much for these very, very important remarks. And I really very much agree, following the trade discourse on these issues, that the narrative is really changing. And I think the DG is also very keen on that, right? Really reiterating more and more the trade needs to be part of the solution rather than a constraint towards these fundamental challenges that we face. I might have a few questions, but in the interest of time, let's first give the floor to the next speakers. So Professor Alessandra Leven, you have the floor. Thank you so much again for joining us.
Thank you so very much for having me. Thank you, Marcos, Ilaria, for the very kind introduction. So to answer this question, I would like to start by saying that the law and legal experts play a key role in fostering a sustainable bioeconomy that provides new sources of economic growth and at the same time accelerates the net zero transition and protects natural capital. And I say sustainable bioeconomy because I think it's important to acknowledge that the bioeconomy does not forcibly equate with sustainable development. There are certain elements of the bioeconomy, for instance, bioenergy and biomass, which, if not approached sustainably, can actually exacerbate global problems and impair implementation of SDGs, particularly those SDGs most related to natural capital. So I think it's safe to say that nature as an independent topic is still relatively new within the trade agenda, but there is also a growing recognition that we do need international trade in order to develop a sustainable bioeconomy. So on the one hand, trade can, of course, spur global consumption and demand, and therefore contribute to exacerbating biodiversity loss, the climate crisis, and the degradation of ecosystems. But on the other hand, trade can play a critical role in promoting biodiversity conservation, sustainable use and restoration, while supporting an equitable and sustainable bioeconomy that actually fosters economic growth and enhances livelihoods. In the past few years, there have been several initiatives and law and policy innovations to address nature in both the global trade and the global economic architectures, such as, besides those already mentioned by Dr. Aiko Lim, the Kunming-Montreal GPF, UNEP's Green Economy Initiative, the TNFD, the UNCTAD Biotrade Initiative, the ISSB standards, and the Brazilian G20 Bioeconomy, just to mention a few. So these innovations also include sectoral approaches, such as the already mentioned 2022 WTO Agreement on Fisheries Subsidies, which is, by the way, hailed as the first multilateral trade agreement focusing on sustainability. And of course, whose second phase failed to be concluded at MC13. Another example at the regional level, which I also think is important, are the recent EU initiatives to establish sustainability requirements for products to enter its markets, such as due diligence requirements and deforestation-free global value chains. But some of these requirements and the fact that the bioeconomy is capital and technology intensive, of course, make it more challenging for developing countries to catch up. So I think advancing a nature positive and equitable bioeconomy has, of course, significant potential, but it also introduces a new set of complexities. And to add to this complexity is the trade governance system. I always like to point out that the trade governance system is rules-based, which amounts to having no quantitative targets per se, and the sustainability side, by contrast, is often outcomes-based. So to conclude, I think an important part of the challenge is to reconcile rules-based and outcomes-based regimes, and also to move away from the idea that trade rules should just stay out of the way of sustainability, and acknowledge the interdependence between nature and trade, and actually embrace the notion that trade rules should proactively contribute to sustainable outcomes. Thank you very much.
Great, thank you so much, Alexandra. And I can see some of the first two speakers converging the fact that, you know, the approach needs to be proactive, right? So very much along the lines of what our dear friend Ho Lim has also told us, right, about the change in narrative, the change in paradigm at the WTO as well. So without further ado, I would now would like to give the floor to Dr. Charlotte Sieber-Gasser, who together with Ted and Claudia will help us address the other question, right, which we provided as a guiding question for our panel. And that is, what is the role of international law in the sustainable management of natural resources for development? Thank you so much, Charlotte, for being with us today.
Thank you so much for having me. It's a pleasure to be here. And of course, we already see that we have a common topic here, and that is coherence. As my job is to shed some light on the role of international law in general on this particular issue, I'd like to draw your attention to the fact that all these different the trade commitments, but also the commitments in the preservation of natural resources, biodiversity, but climate change, etc., have emerged in regulatory silos. And the fact that they have emerged and still are mainly contained in these regulatory silos leads to all these complications and incoherences in the application of those rules. So, of course, the preservation of natural resources has an impact on human rights, on indigenous rights. It also has an impact on trade. But typically, we do not consider all of these aspects and consequences in one single international treaty. At the same time, or as a consequence of these regulatory silos, we see that we have fading support for the liberalization of trade at a global level, but also we are at risk of losing the support of the protection of the environment, particularly in developing countries. It was mentioned before that because we create all these imbalances and negative impacts on trade with the preservation and unilateral actions, that an increasing number of people in developing countries are having doubts whether these new measures are actually in their interest. And we cannot actually afford to lose support both in trade liberalization and in the preservation of the environment. So what we are looking at our research project in Geneva is how to bridge these regulatory silos. And one way to do so is through trade agreements. And we actually see some of these new trade agreements emerging that manage to combine trade liberalization with measures that at the same time actually address potential and expected negative impacts of increasing liberalization through measures that support domestic governments in capacity building, in achieving higher standards in environmental protection, for instance, or through measures that target liberalization to goods and services that are particularly helpful in terms of environmental and social development. One such agreement is the ACCTS, the Agreement on Climate Change, Trade and Sustainability, that was concluded just recently by Switzerland, New Zealand, Costa Rica, and Iceland, and actually shows a way how we could move or use trade to really generate a great potential for the preservation of natural resources by focusing on services and goods alone that actually are helpful to the the preservation of the environment. And also addressing subsidies, harmful subsidies, and greenwashing, which is also a very important topic that hasn't been raised here, and use trade as a vehicle and instrument to essentially move forward in this direction. My final point here would just be that we are seeing that we are on the way to create imbalances in the trading system. It's also a consequence of this regulatory silence. By strengthening environmental protection suddenly, although legal, those measures are completely legal, but creates imbalances in the international trading system that must be addressed one way or another. And one such possible way to address the imbalances that are currently created in the trading system as a consequence of increasing environmental protection is the right to renegotiate those original commitments in trade, so as to create a new balance by taking into consideration also environmental protection and then moving towards bridging those regulatory silos in the future. Thank you.
Thank you so much, Charlotte, for stressing the coherence, the point on coherence and the need for better coherence among these new developments. I would now, without hesitation, give the floor to Ted, who's gonna, as I understand, zoom in with respect to the role of investment law in this discourse. Thank you so much, Ted.
Yeah, thank you so much for having me. So the question, what is the role of international law in sustainable management of natural resources for development? I've looked at this from the perspective of international investment law, so a little bit different from what we've heard so far. But the answer to that question would be that the role is, in my mind at least, ideally a reformed legal regime that facilitates desirable investment projects. In other words, the right type of investment in the right places. But I was really happy to hear so far in the discussion multiple references to policy coherence, and Dr. Siebergasser just talking about regulatory silos, because in order to achieve that, policy coherence at multiple levels of governance is necessary. The role of international law is, in my mind at least, investment law, quite limited, as international investment agreements alone cannot do the job. So how can international investment law particularly be reformed to better define and attract desirable investment? It's a very difficult question to answer in the abstract. There is no one-size-fits-all approach. It's for states to determine the characteristics of desirable investment relevant to their own circumstances. However, once they do so, they must consider how investment law can then be operationalized to get such investment in place. Now, that's a big question, and I have very limited time here, but I'll make three technical and non-exhaustive suggestions in the context of international investment agreements, which might at least work to achieve these goals. One is limiting the definition of investors and investments qualifying for international investment agreement protection. The second consists of pre-establishment rules, and the third is an increased role of the home state in international investment agreements. Now, these suggestions exist and are emerging in newer generation international investment agreements, but it's a very fragmented regime, and these approaches remain scattered across the regime. Looking at the definitions of qualifying investors and qualifying investments, it's important in today's context that international investment agreements limit protection to investments which are made and operated in accordance with host state law, including laws protecting natural resources. Of course, that's not always the case with old generation agreements. International investment agreements can specifically define what types of investments are protected. There are a few examples of this approach being implemented, but they are somewhat scant. Agreements can also provide different levels of protection for different types of investments. For example, establishing procedures for qualifying investments given their contribution to host state sustainability priorities. In terms of pre-establishment rules, mechanisms can be put in place in international investment agreements to promote and protect desirable investment. That could consist of positive list approaches offering protection and incentives to investment in explicitly identified sectors. That could consist of screening mechanisms, including host state clearinghouses, which engage in pre-establishment review ensuring that protection and incentives are funneled to desirable projects. It could also include impact assessment requirements and sustainability screenings in clauses within international investment agreements, which require states to use their best efforts to put pre-establishment mechanisms in place. And then my final point, again, we could go into great detail on all of these points, but we have limited time. But my final point would be to increase the role of the home state in international investment agreements. That's using international investment agreements to implement mechanisms and commitments designed to encourage desirable investment, which emanates from host states. That's technical assistance to outward investors, investment assurance, embassy assistance, all conditioned on well-defined sustainability indicators. That's also home state liability for activity in host states. We see this developing in various sectors of the law, and investment agreements could be another sector or area where this could be useful. Nevertheless, going back to the point of policy coherence, the short answer to the question of what the role of international investment agreements are, international investment law is, it might be that domestic regulatory regimes are just better placed for implementing granular rules aimed at outgoing investment. And I think also another problem in the context of international investment law is that there's little by way of proven evidence-based approaches that can ensure results, right? So there's a lot of questions out there about, do these techniques work? To what extent are they limited? So international investment agreements may not be the most effective means of harnessing foreign direct investment to address host state public interest concerns. I think a lot of critics would strongly agree with that statement. And that includes sustainable management of natural resources for development. They can't do the job alone. So reform of international investment agreements, which is slowly occurring in a very fragmented fashion, must be done in tandem with domestic policies, which are designed to promote and protect desirable investment. These international investment agreements and international investment law, I believe, is at best an important complement to sound domestic policy, like domestic investment laws, investment facilitation initiatives. So there is a symbiotic relationship between international investment agreements and domestic law and policy, but policy coherence at multiple levels of governance is required, which of course is not easy. There's the reality of messy and complicated government structures with rotating casts of characters, which can lead to difficulties in creating and maintaining institutional knowledge and maintaining interinstitutional consistency. Nevertheless, difficulty does not equal impossibility. And I hope that these brief reflections are useful in helping us think about how international investment law can be operationalized to get the right investment to the right places, because we have no time to lose. And I'll stop there. Thank you.
Perfect. Thank you so much, Ted, for your provoking remarks. And I'm sure there will be some reactions to your remarks as well, perhaps even already from Claudia, who's then gonna be next. Thank you so much, Dr. Ituarte Lima, for accepting our invitation.
Thank you. It's a pleasure to be here with you. My way to answer the question will be focusing on prevention. Prevention, it's a cornerstone of international environmental law. Yet it's elusive of what is exactly required by trade and investment law to actually prevent biodiversity loss and ecosystems degradation in its implementation. There's where human rights law, in particular, the newly recognized right to a clean, healthy, and sustainable environment by the UN General Assembly in 2022, which was a result of enormous effort, both by beauty bearers and right holders and business groups. So when we talk about human rights law, normally people's mind think about redress mechanisms exposed to the violations. Preventive approach instead allows us to go for more ex ante, before the degradation of ecosystems and biodiversity loss and associated human rights have been violated. And this is important because once biodiversity loss has occurred, it is often irreparable. So respecting, protecting, and fulfilling human rights related to the environment and biodiversity, specifically in trade and investment law, is a state obligation. independently of other considerations. However, it is also important for policy coherence, for achieving the outcomes that we want to see that benefit all humans and other living beings. So state institutions, businesses, investors must recognize environmental human rights defenders or biosphere defenders, those individuals and organizations that act as stewards of the foundation of life on Earth for their own communities, but also as custodians of Earth stewardship for present and future generations. Doing so will allow us to concentrate on achieving Target 22, on access to information, public participation, and access to justice, and specifically reference to environmental human rights defenders in the Global Biodiversity Framework. However, looking at this entry point target can also help us achieve the Global Biodiversity Framework as a whole. So I will highlight 4 key entry points of doing so. First, in the development and implementation of trade and investment law, they need to be consistent with biodiversity and human rights consideration, including preventing the abuse of the law in cases where biosphere defenders are wanted to be intimidated or silenced. When harm has occurred, accountability, actual consequences of those businesses and investors that not respect international biodiversity and human rights law is critical and preventing reoccurrence. Something concretely would be immediately stopping or canceling projects that are threatening environmental human rights defenders. Defenders are often underfunded, and yet they are providing these critical nature contributions to people, safeguarding them for all. So state and investors can condition the approval of projects to this observance of human rights law in the biodiversity context. And finally, having an enabling environment for environmental human rights defenders allows for engaging in new forms of seeing the economy and the relationship with nature, not in a way that is destructive and short-term and focusing consumption, but rather a generative economy, an economy that focuses on long-term well-being of present and future generations for everyone, everywhere. So this could allow us to have this policy coherence that many people have been raising, and at the same time have this long perspective on the world we want to see. So thank you very much.
Excellent. And Jorge, you're introducing the interveners.
Yes, thank you very much, Marcus. First of all, I would like to thank all the speakers for these very stimulating and interesting contributions and inputs. Of course, they will be very useful in our discussions this day. But without further delay, because of the time constraints, I would like to now introduce our interveners. I will present the 4 of them, and then I will give the floor to the first one. The first intervener is Professor Javiera Cáceres Bustamante. Is an instructor professor at the University of Chile and a PhD fellow at the International Development Department at the London School of Economics and Political Science, and a legal research fellow at CISDL. She focuses her work on international trade, intellectual property investment, among others. The second intervener is Dr. Giada Giacomini. He's the program coordinator for national resources at the Center at the CISDL. Dr. Giacomini also serves as part of the expert network of the program of the UN Harmony with Nature. Our third intervener is Mario Tocas. He is the program manager for the Trade, Finance, and Investment program at the Center for International and Sustainable Development Law, and a PhD candidate at the Graduate Institute of International Development Studies. And last but not least, our fourth presenter is Miss Lorena Jaramillo. She is an officer with the UN Trade and Development. She holds an MBA from the University of Geneva, and he has worked broadly on promoting sustainable sourcing of ingredients and products in supply chain, as well as market access for products coming from biodiversity. He's a very well-known expert in this area. Now I will give the floor first to Lorena Jaramillo to also please ask your question to the speakers. Thank you very much, Lorena.
Thank you very much, Jorge, for the floor and for the invitation. I just wanted to make a brief reflection. We have heard a lot about trade, how we can promote coherence, that we work in silos. But I think it's important what Jorge mentioned at the beginning. We need to change the narrative of how trade can support the biodiversity objectives and reach the communities. Trade, we have seen through the example, is really an underutilized means of implementation to halt and reverse biodiversity loss and implement the GBF. If we consider this TES and UNEP study in 2023, it stated that all the 23 targets under the GBF can be supported by trade. But how do we make this trade to consider social and environmental considerations? How can we use the GBF platform to promote this joint community and bridging the communities between trade, biodiversity, but not only those two communities, we need to bring agriculture, finance, investment, how the other presenter was saying. So I just wanted to put a little bit in the table, how can we use the momentum that we have now in the GBF to promote this changing narrative that trade can support biodiversity conservation. And just I wanted also to highlight one quick comment that I didn't notice it was mentioned too much. It's we need to, we cannot protect what we cannot measure. We need data. We need data to value how much trade and the trade, for example, of biodiversity-based products contribute to the economies, to the GDP. We have developed, we call it the trade and biodiversity statistical tool, where you have some information on trade flows of 189 economies from 2010. You can look at it, see how much the trade of these products represents, and we even have an oceans trade database. So that is some ideas that I wanted to put into the table that I did not see the data. We need data, and that is an area where we need to work together. And how can we use trade to actually contribute? And then just wanted to invite you that we are organizing the Trade Day at the CBD COP16. It's going to be taking place on 26. It's jointly organized by the UN Trade and Development, CBD and WTO Secretariats and UNEP. And I think that can also be a space where we can continue the discussion further. So just those two ideas, and thank you very much for the invitation.
Thank you very much, Lorena, for your very interesting comment and question, and also for informing us about this very interesting event that you will be holding in Cali. We hope that some of us will be there, and we hope that also we can, in a way, of course, partner with you to learn a little bit more about this interesting initiative. Without any further delay, I will give the floor to Professor Javiera Cáceres Bustamante. So you please share your question with us, Javiera. Please go ahead.
Thank you, Jorge. Thank you, Marcus and Ilaria, for hosting this seminar and this plenary session. And also thank you to all the speakers for such an interesting discussion. Well, I know we don't have much time, so I'm just going to pinpoint one question. My question is, how can biodiversity and bioeconomy related international commitments be translated into effective post-treaty actions that ensure the implementation of ambitious climate goals and also what are the alternative mechanisms that we could use to enforce the Global Diversity Framework and legal innovations from MC13, despite the current status of the WTO appellate body? Thank you.
Thank you very much, Javiera, for your very interesting question as well. We will go ahead with the whole set of questions, and then we will start the round for the answer from the speakers. So I will ask also Dr. Giada Giacomini, please, to go ahead and provide your question or comment for the following round of discussions. Thank you very much, Dr. Giada.
Thank you, Professor Cabrera. So my question is related to the fact that I am especially concerned with environmental and social safeguard in investment and trade. So what are the major measures that are in place to promote ethical investments that address biodiversity and climate change concern? But also, how do these measures ensure the protection of the human rights of indigenous peoples and local communities, while also complying with the legal obligations of the Nagoya Protocol and benefit sharing? Thank you.
Thank you very much, Dr. Giada, for your very interesting and specific question on a key topic in international law and international biodiversity law, certainly. So now I will, I think, open the space for the speakers to address some of the questions already posted by the interveners. So I just want to remind you that we need to be very short and very concise because of the time constraints, because we need to finish in about 25 minutes or so, so that please feel free to respond to one or two questions, but do not repeat a long speech. So basically it's to a very concise response to each of the questions. So without any further delay, I will open the floor for the speakers to respond or to address some of the comments and questions already received. And thank you very much for the three interveners. Mario Tocas is not available, so but thank you anyway. I don't know if somebody of the interveners wants to, or maybe somebody else wants to make any comment or yes, Claudia, Dr. Claudia Ituarte.
Yes, so I will address the last question on environmental and social safeguards for ethical investments. So it's important to build on advances that are already there. And this includes the biodiversity safeguards that includes both social and biodiversity safeguards, the voluntary guidelines for safeguards for innovative financing and mechanisms that were already discussed and adopted as part of the COP decision. And those have specific reference to rights of indigenous people, of local communities, and they can very much connect also to the Nagoya Protocol and specifically through legal empowerment methodologies, such as biocultural protocols and paralegals. So we have already hooks there within the Convention of Biological Diversity, and that can be connected to environmental human rights law that is explicitly mentioned within the context of the Global Biodiversity Framework. And I also saw, Jorge, some questions in the chat. Are we also addressing those, or should we wait to address those? There's one that I could also address, but over to you. Let me know what's the process.
I think that perhaps we can address the questions, asked by the interveners first, and then go and address the questions from the general public. I think that's the best way to go forward. Thank you very much, Claudia, for your reply, for your comment. And then I will give the floor to Dr. Houling.
Yeah, thank you. I just wanted to address that very important question about WTO dispute settlement and the appellate body blockage. I think what's important to sort of also put into perspective, as important as it is to find a way forward with the appellate body, and there are discussions with members going on these issues, is to not to forget that in the WTO system, as you all know, what we want is to avoid having a dispute. It's not about putting the dispute as the way forward or as the solution. Actually, that's often the case. I'm stating very basic things, of course, that happens when we have a failure to find a solution. So the question is more coming back to where the earlier panel was about policy coherence. So if we can do this well, we would actually avoid having disputes. And having disputes is basically what the WTO system is about. It's not about trying to get more disputes, if you like. But of course, I fully recognize that we also need the teeth and the so-called bindingness that backs up the agreements. And then the other point I think to keep in mind is that we also have a committee process at the WTO. And some of these committees have been working very effectively. The Technical Barriers to Trade Agreement Committee, for one, the Sanitary and Phytosanitary Agreement Committee would be another one. And in that committee process, you have what, as you know, are called specific trade concerns. And specific trade concerns are actually another vehicle to deal with issues that could arise out of basically, often they're about regulatory issues, and they're often about regulatory incompatibility or queries about certain standards and regulations. And I think that's a really interesting, more flexible way to think about how to resolve a dispute. And from what we have seen, at least in the TBT committee, very few specific trade concerns actually end up becoming disputes. And you actually have quite a lot which is done within the committee stage. And the last point is that some of the issues that we're talking about, in my personal view, don't lend themselves so well to the traditional WTO dispute mechanism way of solving things. And it's a lot more about building regulatory cooperation, policy coherence, trust, and actually win-win-win solutions rather than strictly an adversarial dispute type solution. So those are just a few thoughts. Thank you.
Thank you very much, Dr. Holin, for your remarks as well. Now I will give the floor to Professor Alexandra Lehmann, then Ted, and then Charlotte.
Thank you very much. Thank you very much. Very, very objectively, I would also like to address Javiera's second question. And I would like to point out that domestic strategic litigation with governance purposes and often with transnational features has been deployed successfully in the climate arena. And we just had a fantastic discussion last year at the WTO Public Forum on how transnational climate litigation can also involve trade. At the same time, we have been witnessing, and more recently, a rise in biodiversity and nature-based litigation. So I think there's also a possibility. That strategic, transnational, nature-based litigation can be deployed as a means, as an alternative means of discussing this, their linkages with trade.
Thank you very much. And yes, certainly we are now looking at more activity at the judiciary level on biodiversity-related disputes, especially at least in Latin America, which is, of course, my region. Thank you very much. Please go ahead, Professor Gleason.
Yeah, thank you. So I'd just like to come quickly back to the question about environmental and social safeguards and investment treaty regime. We have to keep in mind, of course, that it's quite different than the trade regime, given the high level of fragmentation, in the sense that there's over 2,500 international investment agreements which are currently in force. And of course, most of those are old generation agreements which were negotiated and concluded before the current impetus for sustainable development and sustainability initiatives was in place. And so in order to answer that question, it's really hard to answer that question because of that level of fragmentation. So there does need to be work. There's a lot of work to do in terms of modifying, amending old generation agreements, or in some cases, leaving such old generation agreements, and engaging in joint interpretation of old generation agreements, and continuing to enter into newer generation investment agreements, which provide a higher level of safeguards for such social and environmental concerns. And even if new generation agreements are put in place, There's the other sort of element of the international investment law regime, which can't be ignored, which is the procedural element, the dispute resolution element, and the investor state dispute settlement mechanism, which has been highly criticized over and over again for repeating inconsistent interpretations of investment law. Even newer generation investment treaty language has been interpreted in ways which is sometimes surprising, where people think, yeah, these safeguards are in place, but then a tribunal interprets the safeguards in a way which leads to an unexpected result. I'm thinking off the top of my head of the Eco Oro versus Colombia case from just a couple of years back. So the ongoing procedural reforms which are occurring in the investor state dispute settlement sphere are another element of the regime which need to be observed, which need these reforms need to continue apace and perhaps a bit quicker than they are. And I'll stop there. Thanks.
Thank you very much, Professor Gleason. Well, now in Costa Rica, this is a major issue because one of the pending cases, one of the most difficult conflicts in the last 15 years because of the mining operation in Costa Rica was finally concluded at ICSID. So we are now talking about, I mean, this type of dispute resolutions more broadly in Costa Rica, based on a bid with the Canadians actually. So thank you very much. So I will give the floor to Charlotte and then to Bala. Charlotte, please go ahead.
Thank you. I'd just like to take up the point that was made about the importance of data quickly to raise. Basically, we are entering in a lot of ways uncharted territory with regards to the combination of trade policy with other policies, social and environmental policies, at the moment, primarily driven by the EU and the unilateral actions from the EU, which will provide us in the coming years with a lot of data. And we already see now from the early impact assessments and studies into potential impacts of these new measures that it's really difficult to predict what the outcome of these policies will be. And my hope would be that with this kind of very huge, risky experiment, we will collect data that will help us in the future to really design those policies in a way that we can better ensure that we are not actually ending up with unwanted negative side effects of those policies. Thank you.
Thank you very much, Charlotte, for your useful comment. Then I will give the floor to Dr. Bala. Bala, please.
Thank you, Jorge. Two very quick points. It's quite heartening to hear about the need for policy coherence. That's what I also mentioned in my intervention. That's something which is going to be very important. It's not going to be easy because we actually are trying to bring two entirely different sectors or stakeholders together into discussing something which is to find a common solution to deal with it. So certainly policy coherency is going to be important. And in the context of the multilateral environmental agreements, we do have many entry points. For example, the convention in its decisions have very clearly indicated that the updating of the national biodiversity strategies need to consider policy coherence as an important element of it. So that's my first point. The second point is also in the context of some of the environmental agreements and the implementation challenges that we have, is that many times we do not hear the role, the impact, or the influence of trade in terms of the discussions on financing. And that, to me personally, is a kind of is a gap, because if you look at the discussions under the Convention on Biodiversity or even the UN Framework Convention, there is a lot of impetus, there is a lot of support and interest to look at private sector engagement in raising the resources required. But we still have not really addressed the key point of what kind of enabling legal and policy frameworks need to be put in place at the national level to deal with it. I think that's something which will be probably an interesting and an emerging issue for a lot of us to start focusing on. Thank you.
Thank you very much, Bala. Yeah, certainly an interesting point and perhaps a gap in the in some of the international multilateral environmental agreements that countries need to really address at the national level. Thank you very much. Well, I think
Yes, thank you, Jorge, and warmest thanks to our interveners for your questions. I also know that Mateus and Ilaria have been especially monitoring our online forums for questions. Only if there's time, Mateus and Ilaria, would you like to share some of the questions or comments that we've received from our amazing online audience? Ilaria.
Yes, thank you, Professor Marcus. We are monitoring the online discussion, and we are happy to report that we had great engagement in the chat, including members from the UK, Egypt, Israel, Sierra Leone. And in particular, there is a question by Mary Ayad from Egypt and US and Laura from the UK that have voiced curiosity to know more about innovative legal provisions in international economic treaties, such as investment or trade treaties, that can support climate change policies. For instance, do you think that including provisions on the rights of nature could be helpful? And I think also Mateus can bring forward a second questions.
Yeah, thanks, Claudia. Again, very happy to report a lot of participation in chat, which is quite well. A second batch of members have asked the panel what are the most promising legal strategies that we can leverage of trade and investment to implement the Global Biodiversity Framework before COP16, which is the Convention of Biological Diversity. And in this sense, other members have also asked in this vein of strategies between trade and investment, are the MC13 outcomes, do they have a role to play in this particular point? Thank you.
Thank you very much. Wonderful questions. If I could give the innovations question back to our panel first. Who would like to intervene on the question about innovations? Yes, Charlotte.
Yes, thank you so much for this question. Actually, in the area of bilateral agreements or regional agreements, and also in just in these policy efforts like the RCEP negotiations, like these voluntary binding to new standards that is not actually a trade agreement, but actually comprises some trade benefits that are just unilaterally provided with efforts to increase standards. We do see a lot of regulatory innovation taking place right now. So let me just make a couple of examples to inspire you, and then maybe we can proceed the discussion later on bilaterally if you're really interested in these new regulatory innovations. So one that actually caused quite a lot of waves and is linked with climate change mitigation is the tariff preferences for sustainable palm oil that were introduced in the EFTA-Indonesia Partnership Agreement. So in this agreement, actually, market access was only opened for sustainably produced palm oil and not for standard palm oil, which meant that farmers, in theory, have an economic or financial incentive to switch their production from to sustainable production in order to get better market access in this case, to the EFTA countries. So that is one way how you can use trade specifically to incentivize countries to take measures towards climate change mitigation. Another one is the ACCTS that I already mentioned. It's actually from the same kind of group of countries that addresses also in this little group of countries the question of of labels, which is actually something that we should not underestimate, because we rely a lot on labels when we decide what kind of trade is useful or not harmful to the environment and so defining reliable labels and preventing therewith greenwashing helps then in a next step to rely on those labels when opening more markets in the future. So that's another example. And then, of course, you have a lot of examples like that it was a precondition to implement and enforce a certain agreement like ILO core labor standards to start and initiate trade negotiations in the first place. We've seen that in the EU-Vietnam negotiations, but also in the recent USMCA, the implementation and enforcement of core labor standards was actually a precondition for the conclusion of the agreement. So let me stop here, but there's actually quite a lot of interesting stuff going on.
Fantastic. I should also give a shout out to Professor Javiera Caceres, because she was part of a CSTL study where we reviewed those kind of regional innovations. But I've got Alessandra, Claudia, and Ike coming in briefly. I would also like to remind speakers of the second question. So if you want to tackle both questions in your intervention, what are the most promising legal strategies to leverage trade and investment for the Global Biodiversity Framework was the question Mateos related to us. Alessandra.
Yes, thank you, Marcus. Just very briefly, I'm not sure if this qualifies as innovation, but I wanted to share very briefly an example from my home country of Brazil with regard to access and benefit sharing policies that underscores the importance of law and policy and legal expertise. Very succinctly, we did have a federal law regarding access and benefit sharing from 2001, which was highly criticized for being too bureaucratic and for discouraging R&D. Through legal innovation, a second law was enacted in 2015, which pretty much allowed us to jump from 3,000 applications for access in almost 15 years to more than 70,000 applications and encompassing 17,000 products. So I think this is just our national experience highlighting the importance of law and policy and legal experts.
Yeah, absolutely. And Claudia.
Yes, I will focus in the question on legal innovations, and here also connected to the issue of nature rights. And one innovation that we see emerging is jurisprudence connecting the rights of nature with the right to a clean, healthy, and sustainable environment, and basing that in constitutional law. And these Global South countries are in the forefront. And often they also refer to both biodiversity, specifically the Convention of Biological Diversity, and others within this jurisprudence. And also key emerging issues that also will be innovative is the use of advisory opinions, specifically in the context of Latin America and the Caribbean, that we are waiting for the advisory opinion that, although the focus will be climate change, is very likely to also bring biodiversity issues, and also the advisory opinion coming soon by the International Court of Justice. So these are ways in which countries, but also civil society, are contributing to advance the debate for a more coherent international law.
Thank you. And in the most recent Environmental Rule of Law report by UNEP, we've actually seen a chapter on rights of nature, which are really proliferating across the world, which is very interesting. Ike, if I could ask you to come back in.
Thanks very much, Marcus. I just wanted to pick up the question that was related to MC13. And just very basically, I think in the very short term, we need as much support as we can get to ensure ratification of the first phase of the fisheries subsidies agreement. So to be very concrete, let's get that deal done. And that will make a big plus for all the things that we're talking about. And at the same time, it also means a huge effort, I think, to move towards conclusion of the second phase of the fisheries subsidies agreement. And we're not that far off. It is not yet there, but it's close, and we need, again, everyone to support that. If we can do those two things, that's a big plus on concrete things that can be achieved. And then the last point would be, let's not lose sight of the UN Plastics Treaty negotiations, which has its timeline to deliver by the end of this year. I know we're talking bioeconomy, biodiversity, but these are all highly interrelated subjects, from climate change, plastics pollution, biodiversity, bioeconomy, and so forth. And we need another result. We need a clear result from the plastics treaty negotiations. And the WTO membership is being supportive. We have the dialogue on plastics pollution that has come up with its set of its statement and recommendations and practices, and actually even offering ways in which there could be greater policy coherence to address pollution from single-use plastics. And so there are clear things here to be done. So if we can do that in this short term, then we can build the bridge to the more medium and longer term. Thank you.
Yes, thank you very much. And we've even seen that some countries are considering making biodiversity in the Global Biodiversity Framework an essential element of their new trade relationships. French government in particular is has tabled a non-paper to the European Commission to convince fellow countries to perhaps consider taking biodiversity much more seriously. And with that, I think, unfortunately, and due to time, we're almost out of time. Perhaps I can pass the chair back to Ilaria.
Thank you so much, Marcus. And indeed, thanks to the keynote, to all the speakers, to all the interveners, and to our wonderful online audience and online moderators who kindly monitored the questions for this very fascinating discussion. Indeed, in the interest of time, I'll be very quick. I'd just like to thank you all. I think we've there was very rich variety in the different topics addressed, but I think a few concepts / keywords have emerged out of our discussion. First is coherence rather than fragmentation. The second is transparency and better data. The third is the need to be sort of building bridges between communities, between different regimes, to really favor a change in the narrative, as was mentioned, right? Being proactive rather than reactive, and certainly making trade part of the solution to biodiversity and more generally environmental challenges that we face. So I would like to thank you all, and I will give then the floor back to Jorge for the closing remarks.
Thank you very much, Hilaria, for your comments and remarks and conclusions. And thank you very much all the participants for your very active role in this plenary session. I really appreciate it. That concludes our plenary session today. Now we will take around 30 minutes for a break for lunch, but please remember that at 1 p.m. Eastern Time, we will be here again for the 2024 Gontier Memorial Lectures, as well as for the announcements of the 2024 Weramantry International Justice Award laureates. So please do join us and continue with us during this afternoon. Again, and thank you very much for your attention and participation.
Warmest of thanks to our three chairs and to our moderators and to our brilliant speakers and interveners, as well as all of the participants who have stayed with us online. Together, your two plenaries have fully caught us up, and everyone is very much appreciating that as they go to their health break. We will see you online if you are a speaker or receiving an award. or a finalist for that award. You will find out. We will meet you 5 or 10 minutes before 1. And if you are joining us in order to hear these incredibly brilliant speakers at 1 o'clock your time, 6 o'clock British Standard Time, 7 o'clock in Geneva, we look forward to seeing you there.